Hi folks, welcome back to another one of our videos on estate planning. My name is Chuck Penzine. I'm an estate planning attorney here in Michigan. In today's video, we're going to talk about powers of attorney and why everyone should have one. Before I get into the various reasons why everyone should have a power of attorney, I wanted to talk a little bit about the types of powers of attorney that can be crafted, what their uses are, how they're applicable to your situation, and so forth. First of all, there is the classic durable power of attorney, which is probably the majority of powers of attorney that are drafted on a daily basis. That power of attorney is created by someone who wants to give authority to another person to act in their place should something happen to them or should there be a need. That other person can step in, make financial decisions, make various real estate decisions, really anything financially that the person could do is allowed under that power of attorney. A durable power of attorney is probably one of the most important types of the powers of attorney that can be drafted. It survives the disability or incompetence or illness of the maker, and in fact allows the party that is granted the authority to continue to make financial decisions even when the person who granted that authority couldn't make those decisions themselves. It's really a special kind of power of attorney that gives broad authority to the party that is the agent under the power of attorney to make a wide variety of financial and economic decisions on behalf of the original maker. Another type of power of attorney that can be drafted is what is known as a limited power of attorney. A principal, the person making the power of attorney, can often draft a power of attorney, for example, to give another party, their agent, the authority to sign a loan document or a closing document if they were selling property or buying property or something of that nature. The specific terms of the power of attorney dictate exactly what authority the agent has, and that agent then works for the principal and signs documents or prepares materials that might be authorized by that principal. Everything is bound by what is included in that power of attorney, and their authority is very, very limited in terms of what they can do, according to what is included in that original agreement. Another type of power of attorney that we frequently hear about is what's been called a springing power of attorney. It's related to a durable power of attorney in that it comes to life or it begins to have power when the principal or the maker of the power of attorney becomes ill or becomes unable to make decisions on their own. It is at that point that the powers in the agreement or in the document spring to life, if you will, upon the authorization or the certification by generally two physicians that the party that made the agreement can't function on their own. So it springs to life when it's needed, but before that time, when the party has all of their faculties, can make their own decisions, it has no power and only becomes effective when there is a circumstance that warrants it. So that's an interesting kind of power of attorney related to the durable power of attorney because it survives the incompetence of the maker, but it only becomes effective when that maker becomes incompetent or ill or under some circumstance that's drafted and put into the original agreement. Now, the most important question that we're going to address today is why do we need a power of attorney? Why should every adult have a power of attorney, whether it's springing, durable, limited, or whatever the circumstance might be? The power of attorney gives the authority for an agent to act in the original person's place should there become a need, should they be out of the country, in the case of perhaps a limited power of attorney, or should they become incompetent if there's some kind of an illness or they suffer an injury that makes them unable to make financial decisions on their own. The power of attorney allows another party, that person's agent, to step in, make financial decisions, whether it's selling real estate, whether it's withdrawing money from retirement accounts or other transactions, paying off bills, even so far as taking out loans or mortgages on real estate, things of that nature. The idea is that if I am injured or I become ill or if for some reason I can't make decisions on my own, I have someone authorized, someone that I know, that I trust, that I can grant that authority to, that can step in, make decisions on my behalf that I trust are going to be in my best interest. Now, the importance of that is it avoids the need to go to court and get what's called a conservatorship. In Michigan, we have this process where somebody can be appointed as another party's conservator, under Michigan law, under Michigan probate law, by the probate court. That would give them authority to act in that person's place and make financial decisions. The difficulty in that regard is that the conservator, the person who's been appointed by the probate court, then has to report back to the court on a fairly regular basis and satisfy the court that they're acting in the best interest of the person for whom they were appointed. The power of attorney grants that authority without the necessity of involving the probate court, without the necessity of reporting back or filing reports and things of that nature to the probate court. They're accountable, of course, to the party that appoints them. They have to act in the best interest of the party that appoints them, and they're limited by the terms of the agreement that's granted that creates the power of attorney. So it really is a private conservatorship, if you think of it that way, or a private granting of authority to act on behalf of another person. We can make those springing in the case of a springing power of attorney, so we don't give them authority now, but it can come to pass at a later time should we become disabled or unable to make our own decisions. We can make it durable so that it survives after I become incompetent or something of that nature. And it really gives a lot of flexibility to a party and protects them so that the family, the friends, or the relatives or whatever of the individual don't have to go to court, pursue judicial relief so that they can pay their bills or fund their care or go into sell their assets to be able to pay for treatments or whatever is necessary towards the end of their life. It really is an efficient way to be able to allow another person to act on your own behalf. I wanted to thank you for stopping by and watching this video. If you find this content helpful or interesting, I would invite you to subscribe or like the video. If you are interested in additional information regarding estate planning or other legal matters, subscribe to my channel. I hope to be posting more videos as the time goes on that you might find interesting and helpful. If you have a specific question or have a specific topic that you would like covered, please note it in the comments below, or send us an email, or contact us through our website, or give us a call. Any of those methods will work, and hopefully we can put together a video that others might find helpful and useful as well. Finally, if you have found this video helpful and need help with your estate planning needs, I invite you to contact me as well. We'd be happy to sit down and talk to you about your estate planning needs, or if you have any other questions about real estate or other legal matters, give us a call. We'll see if we can help you, and we'll be happy to point you in the right direction and try to be of help. Again, thanks for watching, and we'll see you next time.